Hello business owners, my name is Christina Munsters and today we are going to talk about pre-litigation mediation, also sometimes called early mediation, which is one tool in our toolkit of resolving business ownership disputes. We'll talk about what it is, why you would want to use it, and how to incorporate it into your governing documents later on down the line if you want to use it as a proactive measure to be prepared for disputes if they arise in the future. My name is Christina Munsters, and I am a business litigator here at Warner Norcross & Judd. I'm also co-chair of our Business Breakup and Ownership Dispute Litigation Subpractice Group. So what we do is counsel business owners in how to resolve dispute amongst themselves. That could be in cases where businesses are trying to negotiate a buyout or a split of the business owners, or it could be in cases where there's a dispute as to whether there was breach of fiduciary duties or minority oppression or claims like that. Now, our subgroup here is a group that will both counsel in the midst of the disputes to help negotiate a resolution, but we are not afraid to go to court if that's what's necessary. And we represent business owners in cases all across Michigan and nationwide in both litigation and in alternative dispute resolution processes such as mediation. So what is pre-litigation mediation? As the name implies, it is mediation that you do before a lawsuit is even filed. This goes through the typical mediation process where the parties will hire a mediator and pick a day to go and meet with that mediator and try to resolve the claim. Now, if you haven't been through mediation before, what this looks like is both parties sitting in conference rooms, separate conference rooms usually, with the mediator, who will then go back and forth between the two and try and broker a deal. Now, this process, because it's happening before litigation and a little bit outside of the courts, is something that can be tailored to the specific dispute that the parties find themselves in. And that's one of the benefits of doing pre-litigation mediation. So you can hire the mediator and prepare summaries to give to the mediator. And you can also go through a bit of discovery if that's what's needed for your particular case. So sometimes parties will, if it's a valuation issue, agree as part of this process to agree on a valuation firm to run a valuation of the company, or they might need to exchange some documents as part of this process, but it is a more truncated process than going through full-blown litigation. Now, if you go through pre-litigation mediation, that doesn't prevent you from going to litigation down the line if that's necessary. This is just one tool to try and resolve the dispute before you get to the courts, because that can be cheaper and it can be quicker as well. It allows business owners to put the dispute behind them if they're willing to go and sit down with the mediator, have those hard conversations with the other side, resolve the matter, and then they can focus on their other business opportunities. So when would you want to use pre-litigation mediation? You can use it in any circumstance where you have a dispute amongst business owners, but we find it to be particularly effective in cases where the owners agree that they want to split up, but disagree on something like the value of the company. In those circumstances, mediation can be effective without going through the litigation process because everybody's trying to come to the table and just resolve the dispute about, for example, what the value of the ownership shares are, or whether minority discounts or different parts of the buy-sell agreement were triggered. For that type of thing, pre-litigation mediation can be especially effective because it provides a forum for the parties to negotiate what the value of the company is, negotiate whether those minority discounts should be applied without having to go through the full litigation process. Pre-litigation mediation is a tool that you can have in your toolkit if you find yourself in the middle of a dispute now, but it's also a tool that you can incorporate into your governing documents in order to account for disputes that might come up down the line. So for example, you can incorporate a provision into your buy-sell agreement or your membership agreement that says if any disputes arise under this agreement, then the parties agree to go to pre-litigation mediation first before filing a lawsuit. That will make pre-litigation mediation something that is a prerequisite to litigation. So if a party decides that they don't want to come to the table, they don't want to try and do that process, they just want to go to court and they file a lawsuit, the judge will say, nope, you need to go to pre-litigation mediation first. So this is a way that once everybody is all getting along, now they can agree to do this alternative dispute resolution process later and agree that they're all going to come to the table in order to find a resolution without doing full-blown litigation, and that's something that can be enforceable in court. So if you are all getting along now, this can be one way to revise your documents, put this provision in there, and that will force people to come to the table later before filing a lawsuit in order to try and resolve the dispute amongst themselves. So in summary, pre-litigation mediation is a tool in our toolkit that we use to resolve business ownership disputes. We can either use it now if you find yourself in an ownership dispute. You can call one of our attorneys here at Warner Norcross and Judd to help you through this process, represent you in the mediation, hire a mediator, and try and get your dispute resolved without going through the full-blown litigation process. Or it is a tool that you can use now to be proactive and try and prevent litigation down the line in the future by incorporating it into your governing documents. And if you like, you can also call us, and we have a closely held business practice group that is part of our business practice group as well. So our transactional attorneys that can help you incorporate this type of provision into your governing documents as a proactive measure.